Give what? Yeah, Assalamualaikum warahmatullahi wabarakatuh.
Yeah.
Okay. I'm Syed and I will tell you about the cases of Donahue and Stevenson. Okay. Donahue and Stevenson is referred to the snail in the bottle case. Alright. It is because the case established the civil law thought of negligence and oblique businesses to observe a duty of care toward the customer. The event of the case took places while attending a stall. Mrs. May Donahue was given a bottle of ginger purchased by her friends. The bottle was later discovered a content of decomposing snail. Since the bottle was not made of clear glass, Donahue consumed most of its contents before she became aware of the snail. Donahue subsequently took legal action against Mr. David Stevenson, the manufacturer of the ginger beer. Alright, the case was returned to the original court. Stevenson died when the case was finalized and Donahue was awarded a reduced amount of damage of his estate. Absent of a contract, manufacturer own no duty of care to a consumer when putting a product on the market, except if the manufacturer was aware that product was dangerous because of a defect and it was concealed from the customer. The product was dangerous and failed to warn the customers.
Okay, the outcome of Donahue v. Stevenson established several legal principles and precedents. First, negligence. The House of Lords ruling affirmed that negligence is a tort. A plaintiff can take civil actions against a respondent if the respondent's negligence caused the plaintiff injury or loss of property. Second, duty of care. The case established that manufacturers have a duty of care to the end consumers or users of their product. Third, neighbours principle. The Donahue versus Stevenson case produced Lord Atkin's controversial neighbour principle, which extended the tort of negligence beyond the tortfeasor and the immediate party. Okay.
Next is about Ryland v. Fletcher. Ryland v. Fletcher is one of the famous landmark cases in tort. It was an English case in year 1868 and was progenitor of the doctrine of strict liability for abnormally dangerous activities. This case paved the way for judgment of many cases on nuisance liability in case of negligence. Even if it is not on fault, he can be liable for negligence. Strict liability state a person responsible for the damage or loss done occurred to other by his or her activity, without the consent of elements such as negligence, main area, and any kind of remote liability. The fact of the case is both Ryland and Fletcher were neighbors. Ryland owned a mill for whose energy requirement he constructed a water reservoir on his land. He gave this work to independent contractors and engineers. Due to the negligence of the private contractor, the shaft that led the water into the mine, causing heavy loss to him. Fletcher sued Ryland.
So let's continue for the judgment of the cases. The first one is Exchequer Chamber. The Court of Exchequer Chamber held Rylands liable for the damage done to Fletcher. It was held that the defendants owed a duty of care towards the risk which he took by doing unnatural use of his land and bringing any object to his land which was not harmful that time but would be harmful it is escapes. Even if defendant was unaware of the fact that there were shafts which could lead water into plaintiff's mine, he is liable. The second one is the House of Lords. The appellant took the defense that the construction work was being carried by an agency and was inspected by an engineer. It was said that appellants were not at all part of the work. They also were not subjected to know about the security regarding the construction. It was held that it does not matter what care the appellant took, but he was responsible for the damage as he brought to his premises. Appeal was dismissed and compensation was given to the Fletcher.
The impact or significance of these cases towards law relating to insurance. The first one is enjoyment of property. The enjoyment of land was primary in the reason of law claims. This foundation stone is a recurring theme in the common law throughout the age. To which it has been well said that the use of the law consists first in preserving men's person from death and violence, next in securing to them the free enjoyment of their property. Charged to the grand jury at Bristol on the occasion of the 1832 riots over the rejection in the House of Lords of the Reform Bill. The second one is change to the law. In early English common law had, in many instances, imposed liability on those who had caused harm regardless of wrongful intent or negligence. Trespass was considered a remedy for all tortious wrongs, and sometimes used as a synonym for the torts generally. Thank you.
Alright, that's all from us. Thank you.